Hi, everybody. It is November 29, 2022. I'm immigration lawyer John Kasravi coming to you live to talk about U.S. immigration. We're here on TikTok, Instagram, LinkedIn, YouTube, and Facebook as well, where we do this every week, Tuesday at 5 p.m. Pacific, taking your questions live. And for those that do watch the live show, we provide free video consultation raffles. So give away three video consultations. It's a 30-minute show. Every 10 minutes, we'll announce somebody to join and be part of that raffle. All you got to do is like and subscribe and either write a really good question or potentially just write consultation. Good questions are preferred. And my wonderful assistant Katrina will usually announce someone behind the scenes and I'll name them off. Also, if you're interested in learning about a marriage green card, a fiance visa, I have the ultimate marriage green card guide. It's the guide that's really going to help you out. It breaks down the whole process and it's one of the best out there and it's free. All you got to do is go to marriageimmigrationlaw.com and download the PDF there, 40 plus pages that provides a lot of guidance on every step of the process. I think you're going to enjoy it, so definitely check it out there. Again, that's www.marriageimmigrationlaw.com. Now, the YouTube pages have clips and all of this video you can watch there. And this is intended for general immigration guidance only, not for individual guidance as to what you should do with your case. There's a lot going on, so you really need to talk with an attorney in private about that. If you want to schedule a private consultation in my office, all you got to do is email me at info@jqqlaw.com and we schedule a time with myself or one of my wonderful associate attorneys who could help you with that case. Having said that, let's get the show started. All right, so we have a flow of questions coming in. Mohammed Salagan, hi, good to see you. Regular, good evening to you as well. Thank you for coming on. Sue asks, hi, John, do you have any idea of when the visa bulletin family category will move forward? That's a really good question. The quick answer is I have no idea. They don't fill us in on that stuff. But the problem is if you have a green card case pending based on being a brother or sister of a U.S. citizen, being the child of a U.S. citizen or green card holder, or a child or sibling, or those category cases, the visa bulletin, the line that has to move for you to get your turn to get a green card hasn't moved in like over a year. It's just been stuck, and this is a very catastrophic situation because a lot of families are waiting, and a lot of people, for example, are in countries where they need to get out because of the security situation, as well as people who have children that are going to age out of that application process. But unfortunately, right now, December 2022, we're recording this, the visa bulletin has not really moved forward in the family-based category, and that's the line, again, that is needed to move forward for you to get your turn for your green card. And we don't have any indication of when that move forward will actually happen. So we're kind of stuck right now in this situation where a lot of families just don't know what to do. I get emails all the time, people asking me, is there a way to speed it up or something? There's no way to speed up the visa bulletin. That's statutory. You're stuck in that line and you got to go through it. The only way to speed it up is to find another way, another category to be able to get a green card. And that's like a whole thing. If you could apply for one, that may be faster. But unfortunately, as it is right now, the F3, F4 category in particular are stuck in their long waits. But thanks for your question, Sue. I want to take a quick question on what's it called, on Instagram. Aaron Hall, one of my colleagues. Great to see an attorney doing live chat. This is a valuable public service. God bless you, Aaron Hall, a great attorney. If you're interested, if you're from Japan in particular, you're doing E2s, one of the best E2 immigration attorneys that do Japanese cases in particular. A real expert, Aaron Hall. Thank you, Aaron. But yes, I'm a U.S. citizen, and I have my sister's kids. They have visitor visa under 18, and one is 18 and a half. So can I adopt the kids? How long time? You can't do anything for the children. To be able to adopt the kids, first of all, they have to be legally adopted. And if your sister is still with us and stuff, it's not going to happen. Secondly, for immigration purposes, adoption has to happen to finish before the age of 16. So at this point, if they're over 16, it's not going to happen. Talk with the attorney in private, Bunty, but it doesn't look good that you'll be able to do anything in this category to help your siblings anytime and your nieces and nephews or nieces anytime in the future, in the near future. And I ask, good evening, God bless you as well. Thank you for coming on our Instagram page. Again, we're live on Instagram, on TikTok, and Facebook. Yeah, ask all your questions there, and we'll jump on it. Next question comes from JOT, another regular. My 221G takes 7 months in Montreal, Canada for spouse visa. What can I do? So essentially, they did a green card case to the U.S. Embassy in Montreal, Canada. They did their interview, and it was based on being married to a U.S. person. And after the interview, they said, listen, we got to do administrative processing. Just wait. We got to think about it. And 7 months have gone. What do you do in those situations? Well, first, you got to review the case and make sure there's no big issue that exists that makes it problematic. So you say, okay, there's this problem that we can't deal with. But if it's just one of those things where a case gets stuck, what happens a lot, the thing we do nowadays, the immigration attorneys, we file lawsuits against the government for the delay, saying you're taking too long, you have to make a decision. Now, it doesn't guarantee that the decision will be the right decision or positive. Usually it is. It speeds up the process. It's essentially an extra filing fee you have to pay to be able to get a case done when they're stuck in these 221G situations. But schedule a consultation with our office. We can talk about it, about looking into filing a lawsuit for the delay, and a lot of times that fixes things up pretty quickly. UHS, good evening. Good to Jordan, 8350, another regular. Hi, John. It's been a while. Been busy with college. Congrats on getting to the United States. Can I apply for I-765? Actually, you've been in the United States. I remember you have an EB1 case pending. Can I apply for a work permit with my M1 visa, seeing that will be part of my training at the school? So that's a really good question. The M1 visa is a vocational visa. So this is very important to know. We'll make a clip of this, actually, because I've seen people have problems in this scenario. So M1 visa, again, it's a student type visa, but it's a vocational school. So for example, if you're coming here to be a pilot, you go to a pilot school and you get an M1 visa instead of an F1 student visa. And when you do an M1 visa, typically it's 1 year long, and typically, it's 3/4 of the 4-quarter year. And what they do is they have this part of a quarter that they set aside for on-the-job work training. Now, when you're done with studying and you want to do the on-job training, that it's not automatically to work there. You have to apply for a work permit to be able to work in that training period, which is very problematic because it's taking forever to get the work permits done. So it kind of messes up the system. But a lot of schools don't inform their students, or the students don't pay attention, and they just start working for their internship after they finish their M1 vocational school training. And that work is considered unauthorized work. And later on, when you apply for a visa, that violation, if you don't mention it, could be problematic. If you want to change the status, that could lead to misrepresentation or fraud. It could lead to you losing your visa waiver status for working unauthorized. There's a lot of consequences, and it doesn't really come up much because the M1 is not the most used visa, and there's not that much talk about it, and people just don't know. So just be very careful that you don't work on the M1 thinking you don't need a work permit because you'll need one. And so that's it. So you have to apply for the I-765, the form for an employment authorization document, EAD, and make sure to get that. If it's not coming, do an expedite request to get it at time. File early as possible. Talk to your school about it. See what timelines they have on getting these work permits. That's very important. You don't unnecessarily violate your status. So thank you for your question. Good to see you again, Jordan. We have a question on Instagram. Maulana asks, what can I do if I miss the year adjustment of status after a visa becomes available for F4 category using Child Status Protection Act? So this is a really important question. It's kind of hard to explain, but there's a situation where you can get a green card based on your family getting green cards, and you have to be under the age of 21. If you're over 21, it could lead to you losing that, except there is this rule called the Child Status Protection Act, CSPA for short, that says that the time it took for the initial petition, here let's say a family-based petition, the I-130, to prove that the relationship between the U.S. citizen or exists with a foreign person getting the green card, how long that I-130 petition took could be subtracted from the age of the niece or nephew, like the minor child, to bring their age under the age of 21. It's a calculation you have to do. However, that's only the first part. Once you get that and you detract age 21, you have to base it upon the earliest date the visa bulletin for the final action date is current for that category. And you have 1 year to do that once it becomes, once it happens. What I just said may not make sense if you're not really into it, but this is one of those things we got to have consultation review it. But long short of it is, if you didn't make the request within that 1 year and you've aged out, unfortunately at this point you completely lost out, and you have to have a whole new petition, whole new case, start from scratch. If you didn't lock in the Child Status Protection Act age within a year of the time for it being available, unfortunately. So if you've aged out at this point and you can't subtract the time, get to under 21 and reply, and there's been retrogression when it comes to certain categories. These are a lot of technical terms, hopefully not confusing people, but it's a bad situation, Mala. I hope that didn't happen to you, but that's what's going on right now. And that's that. We've got another question on Instagram. Imran asked, my wife applied for my green card application in May 2022, and we got one RFE for the affidavit of support. And we submitted in May 2020. After that, we haven't heard anything. Can we expedite our process? The reality is we don't know how long it's going to take once you submit an RFE. It's up to them. With regard to expediting the process, unlikely it'll be successful. You have to have a good reason to expedite. There's a lot of people cases. What makes your process any different? than other people to want them to expedite yours. If you have a good reason, do it, but it's very unlikely you'll have one. You also ask how you do an expedite. I've done 30 videos on how to exactly step-by-step do expedites on TikTok, on my YouTube clips page, and even here on Instagram. It's kind of harder to find on Instagram because the search view is not as good. But definitely check those out. Talks about the Ombudsman's Office, calling USCIS, letters here, contacting Congress with Ombudsman, USCIS, all these different things. I have it there. Yeah, just check that out and hopefully it can help. Majid asks, my wife has 3-year bar because she overstayed and she's out of the US. Her visitor visa is still valid. Can she come back and do her bar in the United States? So the reality is she has 2 American children. So a 3-year bar happens if you're in the United States and you accumulate unauthorized presence days more than 6 months but less than a year, and you leave the US, you become subject to the 3-year ban. If you have a visa, the reality is the ban means you can't enter. So if she tries to enter, the people at the airport or the port of entry, maybe the land border, should stop her and say, you are inadmissible, you're not allowed to come in. That visa is automatically invalidated, because if you do overstay, your visa becomes invalidated under, I don't know, 222G or something, INA 222G or something like that, 222, something like that. But what the loophole is, if they don't catch it and you come in, there was a new ruling that said, a new policy that said you could run the time in the United States. I can't recommend doing that. It's too risky. Just wait it out the 3 years, unless you want to go through the waiver process or something like that. But there was a USCIS policy that recently came out that said you could run the 3 or 10-year bar within the United States, but you have to be able to enter. I can't recommend misrepresenting a visa that's invalid or void to Customs and Border Protection to enter the United States. So that's my answer to that. But I wish you best for your family. Next question. Just 1 second. Okay. Next one, Fartun asks, hi, sir, I'm waiting. Actually, you know what? My assistant just named Majid. We just talked about 3-year bar. If you like, you won our consultation lottery, take a screenshot of where you are watching this, email it to me so I can see your username. info@jqqlaw is my email address. It's on the screen. And email it to me and we can schedule a private chat really quick to talk about this in a different setting. Again, Majid, you won our free consultation lottery, info@jqqlaw.com. For those just tuning in on the live show, we give away free video consultations. We have 2 more left. All you got to do is like and subscribe, either ask a good question or just try consultation, and you may win a chance. You have 2 more to give away for you to get. Also, if you're interested in marriage or fiance visa cases, all that kind of stuff, download the Ultimate Marriage Green Card Guide at marriageimmigrationlaw.com. That's www.marriageimmigrationlaw.com. Let me take a follow-up question from Mala on Instagram. My aunt applied for citizenship because her father was here 10 years before she was born. She's been waiting 15 months. They haven't opened the case yet. What's the average time? We were asking for what's called an N600 case. There is no average time. She should look into applying for a passport first. But when it comes to immigration, there's no real average times. Imran asked, my field office is Baltimore, and USCIS website says no processing times. I don't have answers about processing times. They're all over the place. You just unfortunately have to wait to see when they're ready. But we'll take some questions with the other applications. Farton asks, hey, sir, I'm waiting my 221G refusal since February 2022. I submitted the request that they asked, so it's a normal long wait. What advice do you have from Kenya? February, it's been 8 months. File a lawsuit if that's something that's appropriate for your case. Schedule, email the office, schedule a consultation, and we can talk with our litigation attorney about that. That's what you got to do in these stuck cases. Thomas asks, do you need a physical I-94 passport during green card interview for adjustment of status? I only have a photocopy. So I don't know what you mean by I-94 passport. You should bring your passport. The I-94 before 2013 was physical. After that's not. It depends on your entry. But if you entered after 2013, it's only a photocopy anyways. If you entered before, it's better to have the original. If you have a copy of it, they should have it in the records too, so it should be okay. But the officer can say, we don't accept this, we want an original or other evidence. It could be a stamp in your passport or maybe even a flight ticket that show you entered. It's better to have originals, but again, if you entered, I think it's after 2013, they don't even have original form I-94, so all you can do is a photocopy. Alex asks, hi, how long after 70 RFE does USA act in the case? There is no timeline for that. Asks, if a couple already had visit visa, newborn is here, how can the visa for newborn as well I don't know what your question is. If a newborn is here, they're born here, they're already a citizen. A visa is only issued by the U.S. Embassy if they leave. So I'm not sure what your question is ongoing. I might have to reword it. Mutha asks, my parents came on a tourist visa and stayed for more than 6 months because of the COVID lockdown. We applied for extension and didn't get any reply. Will we have an issue with coming to U.S. again? Well, if you filed for an extension and got a receipt, you'll probably be okay. But if you didn't get a receipt, meaning your extension of status for the tourist visa was not properly made, your parents haven't had a status accumulating what are called unlawful presence days, which invalidates the visa and can potentially lead to a 3 or 10-year bar on reentry. But if the extension was timely filed and it was appropriately filed, then it shouldn't be a problem, but they could hassle you in the future. Ms. Adams asks, hi, sir, how does the background check work? A normal processing time now? Your questions make sense. How does the background check? I'm not sure what you mean. If you mean how long, there are no timelines. You're at a normal processing time on the 30. You should contact USCIS if it says you're out of processing times. Their processing times are so long that's probably not out of processing times. If it is, that means probably should file a lawsuit at this point. But contact USCIS first. Paranoid Andrew, another regular, can a Canadian national on an O1 visa travel while a change of employer status is pending? If the petition is approved abroad, can the entry be made directly U.S. or via Canada-U.S. border? So that's a good question. I haven't had that scenario. Generally, when you're doing change of status, if you leave the United States, that invalidates the change of status portion. You're stuck outside, unless you have another visa, excuse me, to enter in on. So I wouldn't want to leave with the O1 pending. You probably have to get a visa to come back in. Now, Canadians are what's called visa exempt. So for most types of visa, they could just go to the border and get it, except for the K1 visa and the E2 visa. The O1, probably you could do at the border if you're approved and come with it. Everyone else, but I don't know for sure. I haven't had that scenario happen, so I can't answer that with 100% certainty. Andrew, thank you for your question, though. Miss House follows up. She says her background checks are called a holdup. We don't really know what the reason for the holdup is. They don't tell you if it's a background check issue, but if it's outside, complain and file lawsuits and all that kind of stuff. I'm gonna have to start yelling. I think I'm talking too loud. Hopefully y'all can hear me because my throat's getting away. But we'll take another question there if you got one. Okay, so let's go check it out. Show asks, oath ceremony will be scheduled. Does it mean our M400 is approved? Sam says the oath ceremony will be scheduled. Does it mean M400 approved? Yes and no. So if you're doing citizenship application, you have to do an in-person interview with USCIS. Even if you're in the hospital, come to the hospital, you always have to do an interview for naturalization. And then they approve, if the interview goes well, they approve the interview. I don't know if that means they approve the M400 or not, but essentially, if they say the oath ceremony will be scheduled, it means you pass the interview and you're in line to have an oath ceremony where you go in person, say, I promise to be a good American, all this kind of stuff. Now, I've seen cases where a person gets the interview and right at the interview, they pull it back and say, actually, we did research. We're going to deny your case, or we're going to send you an RFE, or request for evidence, or notice of intent to deny, or all this kind of stuff. So until you get the certificate in your hand, you can't really have that certainty. But in most cases, if you get the notice that the oath ceremony will be scheduled, it means that the interview went well and you're on track to get things going. So that's a good sign right there. Paul asks, in responding to an RFE, another regular, regarding to joint sponsor, do you have to resend everything I previously submitted for the petition as well? No, you have to answer specifically what the RFE is asking for in this situation. Renzo asks, good evening to you too. As Asylee asks, it says good evening to you too. Mohammed follows up, can someone that is waiting for an I-130 approval travel to Canada as a student? Is there any conflict with being a student in Canada and applying for an I-130? I don't know exactly what you mean, because if you have an I-130 petition pending, that's someone else's petitioning for you. You could travel, do whatever you want. I'm not sure. It seems like there's more going on here, Mohammed, than there's this question. So I want to be careful when answering this, and maybe I can't answer directly because you travel now. If you leave, you may not be able to come back in. But if you're already, so I got to see what's going on. But unless you've got the green card, you traveling, go to Canada, or whatever, it doesn't really affect things. Now, sorry, I don't have any more details to get into it. Now we have a ton of questions coming in about timelines. And so just so everyone know, there are no answers about timelines. I have cases I filed the same day, 2 cases exactly the same, almost exactly the same essentially, and one takes 3 months, one takes 1 year. I have embassy interviews. So someone gets scheduled in 6 months, someone gets scheduled 2 years. People do interviews, they get the visa immediately the same day. Other people get it 2 years later. And there's no rhyme or reason. I've been doing this for 10 plus years, hundreds and hundreds of cases on each of these types these main types that we're talking about. And I haven't found a consistency as to adjudication timelines. It's a fool's errand to go in and search for them, other than if it's really long and what they say the estimates are, you can file a lawsuit and complain. But it has to be really, really outside the normal processing time and what's kind of reasonable to do that. So when it comes to work permits, I-751, N-400 citizenship, marriage green cards, consular processing, adjustment of status, change of status, extension of status, whatever you want to get approved, there's no real timelines. And I'm constantly, my estimates are broken because USCIS goes fast or sometimes goes slow. Right now, they're going slow. Everything's taking much longer than normal. And sometimes randomly things get approved really quick. Like we have an example, there's a form type called Form I-824. And this is when there's different reasons for using this form. One is if you submit what's called an I-130 petition, for example, family petition, and you say the foreign family member that wants to get a green card is located in the United States and wants to finish the case while in the United States, where the person accidentally said that the actual foreign national is overseas and they want to go through the embassy to get the green card, come back in. And because of that mistake, you have to submit Form I-824 to say, oh, sorry, I made a mistake. Please transfer the case to the embassy system. And this happens a lot. A lot of people who don't hire lawyers have the situation pop up. We have a lot of videos on this. And it doesn't go a day that I don't get at least 1 to 3 people emailing me because of this error. And it kind of goes to the idea that people say, what does a lawyer do? Well, these people got their I-130 case approved doing it by themselves, but this small error on one line on the bottom left on one of the pages causes them to have to spend $500-600 extra at least and wait potentially 1 or 2 years and may have to do a lawsuit to get it moving. So one is these errors happen. That's why we want to have a lawyer with you. But that aside, the Form I-824, the government says one service center takes 3 months, another one takes 1 year. In practice, it takes 6 months, 12 months at least. And once it's approved, the government is supposed to send the case to the National Visa Center, part of the embassy system. But in practice, a third of the time, they just don't do it, even though you pay them and the case is approved. You have to keep calling them and even file a lawsuit to get them to actually do what they said they would be doing. And so these are the things we see. And so when we say timelines on this, it's kind of weird. What we notice is cases we filed the I-824, which I said usually takes 3, 9, 12 months to get. The cases we filed in October, all of a sudden all got approved within 4 weeks in November. It's kind of crazy. I got a bunch of cases, 6 months, 12 months still pending. And all of a sudden one gets approved after 4 weeks. This is wild. So when people have consultation, that's how long it's going to take. Like maybe a month, maybe 1 year, maybe 2 years. You may have to file a lawsuit. It is that inconsistent. And I was talking actually, I can't name who the person is, but a former USCI supervisor, a person who worked inside the system in Washington, D.C. this morning. I talk with a lot of people in the system all the time. And they're saying, yeah, honestly, they keep changing the rules on us. He was saying, one day they want this much evidence, another day they say this, another day they say we're understaffed. One day they furlough us to say stop working. One day they do this, and morale is really low with USCIS and the immigration system officers in general. And it's just difficult to do their job because they've made it very difficult. The politics of it, the leadership changes. So it's such a moving target that it's not really possible to give a reasonable answer to this kind of stuff. So I know people are going to tune in right now and just ask the same question in about 30 seconds, but that's the whole answer to how long these things take. So I'm sure in a second we'll get to ask a question about how long these things take, but that's the answer. Renzo says, my situation I'm in Peru, in a different country. I'm half Peruvian. I lost my green card. I'm in Peru for 3 years now. What can I do? Well, that's really bad. You should have contacted the embassy and got a special permission to come back in. It's going to be very difficult. You got to jump through a lot of hoops, Renzo. You need to get an attorney, talk to them private. It's a hard thing to fix, but fight and see if you can fix it up. But it's going to be a difficult situation. Arif asks, what do I need to apply for a green card as an asylee? What documents do I need to apply for a green card as an asylee? Well, if you read Form I-485, it has instructions there about what the requirements are. Basically, you need to fill out Form I-485, have your evidentiary documents, personal documents, birth certificates, passports, and the like. And this is such a specific question that's unique to you because we have to know what your situation was in the system and within Asylee, as being Asylee, because sometimes Asylees don't have birth certificates. Sometimes they don't have passports or IDs and stuff like that. Did you use your passport to travel with your entry permit or not? There's a lot of background stuff we need to know to see what's appropriate for your case. So that's why you got to contact a consultation attorney in private to see what's appropriate for you. But the basics are in the instructions for Form I-485. And you need identification documents, primarily birth certificate. But then we got to see what's going on in your case if there's anything extra that's needed. Sometimes people that do asylees have committed some sort of immigration fraud or something that's problematic in the past. It's waived, but you need to ask for a waiver with applications. Then I got to see whether you need that particular waiver or not. So I got to be careful on guiding on this because there's a lot going on there, and I don't want to, not give you the proper information. Turas, B1 visa is about to expire. Should I renew even though I have an I-130 in process? I-130 process doesn't really have anything to do with the B1, but you know what? My assistant Tur just named you as our winner of a raffle. Why don't you take a screenshot of where you're watching this and email it to the office, and we'll have a private consultation. A B1 visa is permission to enter the United States. I-130 means you have a green card case pending. They're separate. Now, if you want to renew a B1, they may deny it because you have I-130 process. But if you need to travel to the United States, for work, you've got a B1 as a work tourist visa, then you should get a shot because you want to travel. But there's a lot more going on here. But let's have a private video consultation to talk about it. And Baya says, hello, I am currently doing my petition. I have some questions. I don't know if I can answer. We'll give it a shot. The National Visa Center sent me a letter, but I'm currently in the United States. Okay, so you have to see whether it's appropriate for you to adjust in the status or not, if you meet the requirements or not. That's a long list of stuff we'd have to go over. Also, you want to make sure the National Visa Center does not close your case if you do decide to adjust in the status, because they could terminate your case for non-activity. You got to keep in communication with them about that. Nova says, what's a green card sponsor petition? I don't know either what that is. There's petitions, family members, there's petitions from employers, and that get the car started. That's that. But the question is kind of vague. I can't answer that. Renzo follows up. My mother's a U.S. citizen. Can't she give me paper to come back to the United States? It's not that simple, Renzo. If you're an adult, that just in general has nothing to do with you. Now, if you're a minor child, your mom can reapply for you, and that relatively is faster. If your mom became a citizen while you had your green card and you were young, maybe you're a citizen already. But it's not that quick for your mom to just do something. That's not going to work that easily. Bell says, can you apply for M400 citizenship while you have an I-751 pending? Yeah, this is a really important question that comes up a lot, and unfortunately, a lot of bad information about this online. We 9 out of 10 times do file for M400 for citizenship, while the removal of conditions from I-751 for marriage cases that are new is still pending. It's up the process from what we've seen. Actually, just lessens the delay, and you'll be able to file for citizenship. So first, you have to see if you have a good I-751 case. If it's not good, then we don't want to file and pay the money for a citizenship case. So, but almost always, they have 9 out of 10 times, you might be the exception. We do file for M400 for citizenship while the I-751 application is pending. And half the time, either I-751 is approved before citizenship interview, or if the I-751 is not approved, you and your spouse go to the citizenship interview together. The officer, at this point, they're used to this and trained for it. They approve or get done with the I-751 application right then, and then they move on and do your citizenship application. And at the end of the show, and my assistant Katrina has named you as our free video consultation raffle winner, Bella. So just take a screenshot where you're watching this and email it to me at info@jqqlaw.com. Again, that's info@jqqlaw.com, and we can have a quick 15-minute video chat to see what's going on and talk in private about it. I'll name one more person. One more question, and we'll call it a day. Nas asks, can I travel on an I-131 while my I-130 hasn't finalized and married to a U.S. citizen? So I'm assuming you not only filed an I-130, but you also have an I-485 application for adjustment of status, because that is what you could use to get what's called advanced parole travel document from I-131. If you have the advanced parole travel document, you may have the option to travel, but we got to go back and look to see if you have any issues. Are there criminal history? Are there any bad immigration violations that could be problematic? Most of them won't, but we got to see. But I see what the status of your case is. Is it a strong case or something? We don't want your case to be denied while you're overseas. So we have to review the case in your background and make sure it's, how bad it is or if it's clean. And then at the end of the day, you run a risk. You're taking a risk to travel, come back. You can't guarantee it's going to work. Most likely it will if you have a clean background, but you can't guarantee it. So you got to analyze and see, is it worth the risk? We just had a client, unfortunately, his dad is really sick and it's not going well. He had to go and visit his dad in the hospital. We got emergency advance parole for my own 31 for him to go. And in that case, you got to see your family member, and his background was clear, so I thought it's okay. There's a risk, but you got to judge whether that risk is worth it. If you just want to go on vacation, I don't recommend doing that. But again, with regard to what you can do in your case, I don't know the details about you and your background, your marriage, or your documents, so I can't give individual guidance on that. So thank you, everybody who's tuned in. We get questions about cases that are pending and too long, stuff like that. If you're interested in filing an immigration lawsuit, email us at info@jqqlaw.com to schedule a formal consultation with me and our litigation attorney to see what's going on and potentially file a lawsuit to get your case going. I'm John Khosravi, immigration lawyer located here in Los Angeles. Like and subscribe if you haven't already. Leave a good comment wherever you're watching this. And we'll be back again next Tuesday, 5 p.m. Pacific time to take your educational questions live. Until then, God bless you.